Start. The submissions of the learned counsel for the appellants is that assuming that the commissioner of a division does not have a place in the hierarchy of educational authorities as per the scheme of the acts under bracket supra and the rules under bracket supra but comma section 12 of the 1972 act confers power on the director to inspect or cause to be inspected any basic school and comma under subsection under bracket 2 thereof comma he may direct the management of a basic school to remove any defect oblique deficiency found on inspection or otherwise stop. The term otherwise used in subsection under bracket 2 is of significance and enables the director to take information from various other sources also comma to initiate and take action contemplated under the acts and the rules stop. Subsection under bracket 3 of section 12 of the 1972 act empowers the director to refer the case to the board for withdrawal of recognition of such school if management of basic school fails to comply with the direction made under subsection under bracket 2 stop. It is submitted that section 13 of the 1972 act envisages control by the state government by providing that the board shall carry out such directions as may be issued to it from time to time by the state government for the efficient administration of the act staff. As 1978 rules are framed and notified in exercise of power conferred upon the state government by section 19 of 1972 Act, any information received by the state government in respect of violation of the provisions of 1972 Act or 1978 rules, could be passed on to the authorities to ensure proper administration of the provisions of the 1972 Act. Therefore, it cannot be said that the commissioner held no jurisdiction to direct for an inquiry staff. It is submitted that even assuming that commissioner held no jurisdiction to bind the educational authorities with the report submitted by the inquiry committee set up under its directions, even then the educational authorities were empowered to take notice of the report and proceed further in accordance with law staff. It was urged that by quashing the report, the notice issued in pursuance of the report and the order issued by the state government, the learned single judge has closed the doors to scrutinize the legality and validity of the appointment, that is, whether the appointments were made by following the procedure prescribed by the 1978 rules staff para. In addition to above, it was urged on behalf of the appellants that Section 4 of the 1978 Act empowers the education officer to inspect or cause to be inspected any institution or call for such information and records from its management with regard to payment of salaries to its teachers or employees or give its management any direction for the observance of such canons of financial property, including any direction for retrenchment of any teacher or employee, for prohibition of any wasteful expenditure, as he thinks fit staff. It is urged that the BSA is the education officer as per the definition under section 2 under bracket B of the 1978 Act staff. Thus, the so cause notices impugned in the writ petitions, issued by the BSA, were referable to section 4 of the 1978 Act and were not liable